5 seconds to go. Start. The High Court also rejected the contention made on behalf of the appellants that they had become the owners of the suit property on the basis of adverse possession, but that aspect of the matter has not been argued before us, and we do not want to disturb the finding of the High Court on that issue. Turning back to the three post 1900 deeds, we are not in agreement with the reasoning of the High Court in full. On remarriage of Chiruthi after the death of Madhavan, her title or interest over the suit property stood lapsed in terms of Section 2 of the 1856 Act. Thus, Chiruthi's right to deal with property derived from Madhavan stood extinguished so far as the deed of 14th July 1910 is concerned, Exhibit A20. But it was not Chiruthi alone who had executed that instrument. It was Nangeli and also Sanskaran, son of Chiruthi, who had executed it and remained valid legal heirs of Madhavan since deceased. There is no conflict, at least on that point. We have no material before us that Madhavan had any other legal heir. In such a situation, even if we discount Chiruthi's title over the property forming subject of lease, it stood conveyed by its actual owners, that is, Nangeli and Sanskaran. To that extent, we accept the validity of the lease deed that was otherwise proved in the trial court. Once we find the Exhibit A20 to be valid conveyance, we do not think the corollary transaction, which is marked as Exhibit A1 bearing number 2329 of 1910, by which the same property was leased back to Chiruthi and Kutti Parvan, to be invalid. These back-to-back transactions may be unusual, but in absence of any evidence pointing to any illegality, we hold them to be valid. The High Court, on finding that these deeds are valid, restored the trial court's judgment and decree. The underlying reasoning of the High Court was that Chiruthi had legitimate right over the property. We, however, find a flaw in this reasoning of the judgment of the High Court. The High Court, as also the trial court, have held that since the deeds were proved, implying that Chiruthi had the right to execute the lease deed on 14th July 1910, so far as the deed of release is concerned, the same might entitle her to be the beneficiary as a lessee thereof. But it would be trite to repeat that even if subsistence of a deed is proved in evidence, the title of the executing person, in this case Chiruthi, does not automatically stand confirmed. If a document seeking to convey immovable property ex facie reveals that the conveyor does not have the title over the same, specific declaration that the document is invalid would not be necessary. The court can examine the title in the event any party to the proceeding sets up this defense. Chiruthi could not convey any property over which she did not have any right or title. Her right, if any, would stem from the second deed of lease, Exhibit A1. We are conscious of the fact that no claim was made before any forum for invalidating the deed dated 14th July 1910, Exhibit A20. But in absence of proper title over the subject property, that lease deed, even if she was its sole lessor, would not have had been legally valid or enforceable. If right title or interest in certain property is sought conveyed, by a person by an instrument who herself does not possess any such form of entitlement on the subject being conveyed, even with a subsisting deed of conveyance on such property, the grantee on her successors in interest will not have legal right to enforce the right the latter may have derived from such an instrument. Stop.